Hello ladies and gentlemen, my name is Wahiga K. Muturi and welcome to KYR Africa. Unajua haki yako? Do you know your rights? So, what do? We're actually the comprehensive legal advice and resource for your rights, actually about your rights. So this is what we do, this is what we help you do, guys, learn from us, and this is what we also want you to be able to actually know your rights and don't defend, because these streets, banner, they are not your friends. And today we're actually talking about a topic which is very interesting, debt recovery. And there's also, can I say debt loss?
Well, you can, okay. It's understood that the meaning is the same, yes?
Oh, the meaning is the same, okay. Anyway, introducing our guest for the day, our lawyer extraordinaire, Mr. Thiongo Tafadhali.
Thank you very much, Wahiga. As he said, my name is Thiongo Nganga. I'm an advocate of the High Court of Kenya, practicing in Nairobi, and today we're going to be discussing debt recovery.
Yes. So you've already seen the case that we are thinking about today.
Yes.
How exactly, what is the recourse? Nimeanza kujua hizo terms. What exactly is the recourse for such a case?
In such a case, there have been a number of violations of the rights of the parties involved, particularly the borrowers who had taken, I think, a sum of money and had secured it on some of their property.
Yes.
Before we talk about recourse, we should talk about the proper steps that are to be taken in that kind of transaction. First, it's always important to have a written contract that documents what money has been given to who and the terms under which it's going to be repaid. And as always, it's important that an advocate advises in that kind of transaction to avoid an instant where the borrower, more often than not, is taken advantage of by over-eager lender.
But hata sasa umekuwa technical. So turudi mashinani kidogo. Nimeomba mboga, nitalipa kesho.
Yeah.
Nikose kulipa. How is that actually something very serious in terms especially of law?
Okay.
Yeah.
Legally, I don't know what you mean by serious, but a debt is a debt, in fact. You do know the story of Shylock. A debt is in fact a debt. So hiyo ni deni na ni vizuri ilipwe. But hiyo ni deni iko covered na custom ya business hapo sokoni ama kwa duka penye umechukua. Kwa hivyo ukisema utalipa, huwa kuna hiyo mwelewano ama understanding kati yako na mwenye amekupatia vile utalipa.
Okay.
Lakini kwa hiyo instance ambayo tulikuwa tunaangalia, the circumstances were a little more complex than that. And you could see the repercussions where some people forcefully came into the house of the borrower and we even were about to get physical with some of the family members. So in that kind of instance, it's important to have the full protection of the law to first and foremost document that transaction, as I have said. But
by document, what exactly do you mean by document?
Have a written contract, preferably prepared by an advocate that sets out the terms under which the loan has been taken and how it's going to be repaid.
In this scenario, tumeketi hapo wawili,
yes.
Then I write it on a serviette.
Okay.
Nasema, nimepe Thiongo 1,000 bob.
Yes.
He said he'll refund by this time, and then you don't meet that.
Okay.
Actually, tuseme 20 hata, tuinue basi, tuseme 20, because hiyo inakaa ni serious sana.
Yes.
At least tukiandika 20,000 kwa serviette, hiyo serviette tunaweza eka kando.
Yeah.
So, in such a case,
yes.
Ukose kulipa.
Yeah.
How do I sort that?
Well, it's important that you understand that it's actually a binding contract. It's just that it's missing maybe the kind of formality that would go with the ordinary contract. Now,
what is this formality, Kwanza?
There's one essential feature I think that was missing. For you to be able to take that serviette and the terms that you've written and take them to court and enforce, it has to be stamped. What that means is lazima ipelekwe kwa registry ya lands na ifanywe assessment.
Lands?
Ndio.
Yeah, wow. Lands. But ni deni. Hatuongei deni ya shamba.
Ya shamba, but lazima kuna kitu inaitwa stamp duty. Na stamp duty ulipwa through the lands registry.
Only?
Yes.
Wow.
But it's actually collected by the Kenya Revenue Authority through the lands registry. So lazima hiyo document yako itaenda ikuwe stamped. Na after imekuwa stamped,
which inani cost?
Itakucost, ndio. Ita depend on your 20,000. Hiyo ndio itakuwa the basis ya kuassess.
Okay.
So after your document imekuwa stamped, sasa unaweza ukaipeleka kotini na ukarely on that to prove that there was actually a situation or a transaction in which you gave money to an individual and you actually owed. So the form really is not as critical as the evidence of an agreement between the two of you that money has been given and it should be paid back.
Okay, imekuwa serious. So mimi nataka kupeana deni family.
Yeah.
Do I need to still do the same thing?
Well, there are a number of important considerations that you take into account. Most important being the value of the amount of money that you're giving. See, even with family members, disputes always arise and memories change and fade. So you could give someone 100,000 and you forget and you think it was 110 or 90. So it's always important to document the specific terms of the loan that you have given, so that in future, in case of any dispute, there's the benefit of that written contract, which serves as evidence, and there's proof that both of you signed. So both of you agreed to the terms of that agreement.
Okay. So Oti hapa anasema,
Yes.
I gave money to my family
Yes.
members, my father to be exact. Na akasema atarudisha, and it was supposedly a binding agreement.
Yes.
By speech sikuwa na copy.
Yeah.
Can I take him to court for that?
It's possible to take him to court for that, and you could actually sue on the basis of the agreement that was there between you. But like I said, in any circumstance like that, it's always advisable as the first step to have that documented. Yes.
Is there any other way to document apart kuandika mahali? Can we do it by like ni record?
Hiyo pia ni possible to record terms of agreement yenyu. But written evidence is always the best. It's always the most suitable, especially in instances where a loan has been given from one party to the other.
Okay. So how do I go around this kuitisha deni yangu? The 20,000 that I gave you.
Yes.
How do I go about actually finding a way to get it from you legally?
Yes. The first and foremost is that because we had a written, like I said, it's important to have it in writing. I understand that I was supposed to pay at this time and under these conditions, or in certain installments. So the most important thing would be to communicate that time to pay is here. You could do that by way of a letter, or even sending an email, or just communicating. Once the borrower understands that they have to repay, then the other obligations are come into play. In the event that I do fail to pay, I will advise, as I did before, that it's important to speak to an advocate who can advise you on taking the right steps, including approaching a court to have your rights remedied.
Okay.
According to law.
So you gave me a loan, nimeshindwa kabisa kulipa.
Ndio. Kitu ambayo itafanyika hapo ni advocate wako ataandika demand ambayo ni barua iko recognized in law, na on the basis of that demand mimi nitajua kuwa niko na deni yako na nafaa kulipa katika muda wa siku 10 ama 14, ambapo nisipolipa utanishtaki. In the event that I fail to pay, you will take me to court, and you will institute proceedings in the civil court, and the basis of those proceedings will be the fact that I owe you money and I refuse to pay.
Okay.
We will go through the motions of the court process, including the hearings, through which you will prove.
Who pays for that?
That's your expense.
Okay.
But in the end, you will be able to recover in terms of what are known as costs.
Damages?
The damages will be the loan that you gave me, that amount.
Okay.
And the costs will be the expenses in the bringing the case to court and seeing it to its conclusion.
Okay. Okay, that's interesting. So guys, we've been talking about debt recovery, but we even spoke a lot about personal,
Yes.
more than landlord, rent, na vitu ka hizo, or public one, and even company debt, right? Because that's another story altogether. In this case, ni landlord kind of case, amekuja kuitisha deni because ameshindwa kulipa nyumba.
Yes.
How do we sort that? And si ati nimekataa kulipa.
Ndio.
Do ina come.
Yeah.
But sina saizi.
Okay.
But I am very sure ikikuja, you're first on my list. Yeah. And you're the landlord.
Okay.
What are my rights? And also what are your rights as the landlord?
Okay. The relationship between a landlord and a tenant is a bit different between just a private debtor, between a borrower and a lender. The landlord has a very special power, which is the power to restrain, which means the landlord usipoweza kulipa within the time iko agreed, akona right ya kufunga kwako na hizo bidhaa zako ambazo ziko hapo, anaweza akaweka ni kama declaration of sort ambayo atakuja zikuwe valued, na in the event you are unable to pay within the time provided for in law, atakuja aziuze
kwa auction.
Ndio.
Right. So ana hiyo right?
Akona hiyo right under law. Ndio.
What? Guys, that brings me to the end of our conversation today. We are talking about debt recovery. My name is Wahiga K. Muturi. I've been your host for the session. for KYR Africa, which is your comprehensive platform for legal advice and resources on your rights. Thank you so much. Join us next time.